Well, good afternoon, everyone. I am Jacob Stein, and welcome to this presentation on asset protection planning. I cannot see you guys. I can see your names, but I do have the chat box open. So if you have questions during this presentation, please feel free to ask questions. Questions are always welcome, and I think will make this discussion a lot more interesting if I'm not the only one speaking, right? I've been practicing asset protection planning for about 25 years, and we represent everyone from mom and pop business owners facing some sort of usually unexpected financial adversity to extremely wealthy families who are just looking to get their affairs in order. I'll give you a couple of quick examples of when our clients are looking to engage in asset protection planning, because I think that's important to set those expectations and get that understanding of when are we trying to protect assets. So usually, and by usually I would say about 90% of the time, our clients are looking to protect assets when something bad has already happened to them, meaning they were already in a car accident, or they were served with a lawsuit, or they expect that in the near future they're going to default on a bank loan, or they got some sort of a letter from a government agency advising them that they will be, investigated or what have you. So the vast majority of our clients plan after the fact. It doesn't matter what their level of wealth is. It doesn't matter what sort of advisors they employ. Most people live in a world where bad things happen to others, right? So their experience does not tell them that they need to do something, right? Until something bad has happened to them, and then they're facing the prospect of maybe losing everything that they have. So in this economic climate, we're seeing lots and lots and lots of clients who are facing some sort of a personal guarantee call. So they sign a personal guarantee on a bank loan, they sign a personal guarantee on a lease, and the business is failing. They want to walk away from their restaurant lease or office lease or whatever. And they remember that at some point in time, they sign a personal guarantee and their home is on the line, their life savings are now on the line, and so forth. We represent a lot of employers, especially in California, who are facing some sort of a lawsuit. Usually these are lawsuits by employees, including these class action lawsuits under PAGA. And we represent lots of businesses or business owners who are going through some sort of a dispute. Sometimes it's lawsuits between business partners. Sometimes they're being pursued by the FTC or the SEC or the CBP or any other three-letter acronym government agency. Your ordinary tort lawsuits and things of that nature. So what is asset protection planning all about? Well, we're looking to set up structures that would enable our clients to own their assets and make it more difficult, more expensive for plaintiffs and creditors to go after those assets. What asset protection planning is not about, it's not about hiding assets. And here I need to make kind of an important clarification. There is nothing wrong with hiding assets. Hiding assets is not illegal, and hiding assets may be helpful, but it's not substantively helpful, meaning that if our clients rely on hiding assets, we can conceive of a day when our client will be pulled into a debtor's examination or in some sort of other setting where they have to answer questions under penalty of perjury, right? They will be asked questions about their assets. And if they relied solely on hiding assets, well, then they haven't really accomplished anything, right? They have to answer questions and they will end up perjuring themselves, right? If they're relying on hiding assets as a means of protection. Having said that, hiding assets is not a bad idea, because if the plaintiff cannot find the assets in the first place, or if a creditor cannot find the assets, perhaps they will never file that lawsuit to begin with, right? Because their client will appear to be judgment-proof. If they are already in litigation and they cannot find the assets, well, perhaps they're more willing to settle, right? It's much better to get something than to get nothing. But we usually want to combine hiding of the assets, if that's what our client is inclined to do, with substantive protection. And we'll get into the substantive protection structures in a second. And one kind of final point. Despite what we call this area of the law, asset protection, our goal is rarely to protect assets, meaning protect in a way that makes assets unreachable. And that is rarely our goal because bulletproof asset protection is rarely in the cards. That's just rare. You know, it used to, when I first started practicing in this area 20 some years ago, you know, we would set up all sorts of structures and plaintiffs and creditors would have no idea what to make of them. And it just worked, right? Because this was sort of new. People didn't know what to make of it. Today, most plaintiffs and creditors, lawyers and judges are certainly aware of various asset protection structures. Bankruptcy lawyers are aware of these structures, right? They know what a trust is. They know how to attack a trust. They know how to try to get around LLC charging order limitations, how to pursue money that's overseas, so on and so forth. So today, our objective has shifted a bit, right? And it's no longer to make assets unreachable. There may be a couple of circumstances when we can do that, but usually our objective is not to make assets unreachable. It is to make assets more difficult and more expensive to reach, right? More difficult and more expensive. And experience tells us, and we have a couple thousand cases of experience under the belt, that when you do make assets more difficult and more expensive to reach by placing them into some sort of structures, doing something with them, in about 30% of cases, the plaintiff will just walk away and they will never come after our client in the first place. They'll either never bring a lawsuit, or if they already have a judgment or they're already in litigation, they will just not even try to pursue our client's assets. So 30% of the time, our client just gets a free walk. The remaining cases, vast majority of the remaining cases, the parties settle with each other, but now they're settling on terms that are more favorable to our client, to the debtor. And then maybe 1 or 2% of cases, more like 1% of cases, we would see the plaintiff try to pierce the structures we have established and try to argue that what we have done was a fraudulent conveyance, what's nowadays called voidable conveyance, and that it should not work, and try to reach the transferred assets. When we are looking to set up asset protection structures, there are a lot of different options as to what we can do, a lot of different options. It's not like one, magic bullet structure, and we just discuss like, this is what you do, this is the one structure and it works and you don't need to know anything else. That certainly would make it for a much shorter conversation. There are a lot of different options. I would say that in our practice, we use, give or take, about 20 structures. And some of these structures will have different iterations and permutations. So there are a lot of different choices. And none of these are right or wrong, right? If you go on the internet and you start doing some research on asset protection structures, you're not going to find like the one structure that is perfect. And if you do come across a website that says, we have this one structure that is perfect, run as fast as you can. No structure is perfect, right? So depending on the client's circumstances, depending on who the creditor is, how risk averse our client is, what are the assets being protected, how much is at stake, right? All of these different things, like, are we planning this in advance of something that happening, or is it response? So different options come into play, and we need to pick which is the better option for a particular client. So what we do in our practice is we look at these different factors. So we look at how risk averse is our client, because you will find that two different clients in exactly same set of circumstances may choose to do very different things to protect their assets, right? One of them may be very risk averse, and they want to do the most that they can to protect their assets. And the other client is more of a risk taker, and they will do something minimal, right? Then we need to look at who is coming after our client, who is the creditor. And that will tell us, hopefully, or we try to figure out, how aggressively will this creditor pursue our client? How diligent will they be in that pursuit? How intelligent are they as a creditor? How knowledgeable are they, right? When it comes to different collection remedies and so forth. So we need to know who the creditor is. And some creditors will fall sort of into broad baskets. Like, for example, most government agencies are not going to be very aggressive creditors. They may be very powerful creditors, but they're often not very aggressive because they're giant bureaucracies. They just don't have often the capability of being that aggressive. Plaintiffs law firms, right? Plaintiffs law firm, in our experience, they may be great at getting a judgment against the client, right? Let's say they're great litigators, great trial lawyers. They get a judgment against the debtor, but often they don't have the collection experience to then do something with that judgment. So we need to try to develop a sense, like, who is it we're going up against? Is it a bank? If it's a large bank, again, usually big bureaucracy, not super aggressive. A small local bank, very aggressive, right? So we need to know our plaintiffs and creditors. From practical experience, I will tell you that the most difficult, most powerful, I would say, creditor to go up against would be either a former spouse or a former business partner. Because in those cases, it's not just about the dollars, right? There's an emotional investment that the other side has in that case. And very often with those cases, it's not enough to just make assets difficult and expensive to go after, because the other side is not going to stop just because it's difficult, right? They're out for blood. So either we make it just pretty much impossible, or as close as we can to impossible, to get at our clients' assets, or we don't even bother in the first place. So very, very important to figure out who's going to be coming after our clients' assets and how aggressive they will be. The timing of the work is really important, right? So as I said, the vast majority of clients come to us after something bad has happened. And if we're planning after something bad has happened, let's say the client was already in a car accident. Now the plaintiff has the ability to bring a avoidable conveyance action and try to set aside the asset transfer that we engaged in. So we need to be mindful of that. If they're going to bring an avoidable conveyance action, how do we plan for that? We need to anticipate it. We need to make it more difficult for them to have a successful avoidable conveyance attack. And if we think that we can succeed, right, with defending a possible avoidable conveyance attack, what used to be called a fraudulent transfer, now we're looking at a more pragmatic, more practical approach, which is like, how do we just make assets unreachable? Is that in the cards at all? Because sometimes it may be, like, as I said, there are one or two structures where we can make assets unreachable. And if the assets are unreachable, who cares about avoidable conveyances? Because the creditor's remedy most of the time is to reach the transferred asset. And if it's not reachable, it's not reachable, right? And then finally, we look at what are the specific assets that we're looking to protect, because different structures will come into play if we're looking to protect a client's personal residence or an apartment building or an interest in a closely held business or IP or bank or retirement plan, so on and so forth. So putting all of these different factors and questions together, we try to figure out what are the appropriate structures that we're going to use for that particular client. And again, there is no right or wrong solution. At least I don't believe there is a right or a wrong solution, right? Depending on this particular client we are working with, different options can make more or less sense. And our job, I think, as a lawyer, is to develop these options for the client, present the options to the client, educate the client a bit, right, as to various levels of protection the different options will present to them. Tax consequences, perhaps, if any apply. How difficult will his life be, right, as a result of setting up these structures? And once we've gone through this analysis and the client has made his decisions, then we started setting up the structures. So let's get into the specific structures, right, that are frequently used to protect assets. And again, if you guys have any questions, you're welcome to ask in the chat protocol. You can just send it directly to me. If you don't want people to see your question, I'm not going to then name names. We can ask openly. That's welcome too. And if there's a particular topic you would like me to spend more time on, or a topic I'm not getting into that you would like me to address, you're welcome to do so. And also just for later on, I've always made it a point over the 20-some years I've been lecturing to always answer questions from anyone who's attended any of my seminars. So you can always just email me, and I get these emails almost on a daily basis. Just email me and say, hey, Jacob, I took your class and I have a question, and I'm happy to answer them if I'm able to. Okay, so let's get into the specific planning structures in the time we have left. Let me put on my headset. Oh. Hopefully you guys can hear me, and I think our host will let us know if he cannot. Okay, I have a question from Alex. I'd be interested to know the range of fees involved in asset protection. You know, Alex, that varies greatly. It really does depend on what are the different structures being set up. It depends on the risk exposure that the client has and that the law firm may have, which I was not really planning on getting into, because in an hour-long presentation, we don't really have that much time to get into what a lawyer's exposure may be, but you may have exposure for aiding and abetting an avoidable conveyance. So what we typically see in our practice, and again, just really so circumstances driven, I would say anywhere from 5,000 on the very low end to upward of 70, 80,000 on the high end. And then there are exceptions, right? There may be structures that are incredibly more expensive. There are structures that are sort of one-time use structures that are just incredibly unique, or just the circumstances are such that they dictate extremely complex work. So like right now, we're setting up a structure for a client that spans multiple countries, several tiers of ownership structures in the entity diagram, going from country to country to country. And some of these countries, we just have to have a lot of business substance for the structure we're setting up. We have to employ local people, just because it becomes incredibly expensive. But I would say most clients would fall somewhere, I don't know, I would say $10,000 to $20,000 range. And I'm speaking not just from our own standpoint, but from what I know, the going rates for various asset protection structures for other law firms that do this kind of work. And it's a very small community. In the time I've been practicing asset protection, as I said, over 20 years, it's pretty much the exact same people who have been practicing this across the country. And it is a very small community. We all kind of tend to know each other, or at least of each other. And we often will have the same clients, go to a couple different people. So we get a good sense of like, what is the work that other folks do? What are they charging? What are they quoting? It's a little bit of a small community. And I have a follow-up question. I'm curious to know how you, I guess meaning me, got involved in asset protection. I'm a tax lawyer by background. I started at Paul Hastings many years ago. And then when I left Paul Hastings, about 20 years ago, and I was setting up my own practice. I was trying to figure out how I am going to market myself and sell myself. I realized I did not want to be competing with all these other amazing tax lawyers out there. There are just so many of them. And my partner at the time, who I joined forces with, happened to be practicing in asset protection. And I'm like, oh, no one is marketing asset protection. I can market myself here, and having a tax background is extremely helpful in asset protection, because pretty much everything we do has some sort of tax consequences. So I slowly got into asset protection that way, and at some point in time just realized that the asset protection practice dwarfed my tax practice and became known for asset protection. So it's just how things develop, out of need, right, out of necessity. Okay, so let's get into some of the specific planning structures. And the first one is for California clients, which I presume for most of you guys, your clients are for the most part in California. And that's what do you do if you have a married couple and only one of them is exposed to some sort of a claim, right? A lawsuit claim, what have you, potential claim. So when we're representing a married couple, right? California being a community property state, we look for a way to solve the problem that community property creates for us. And in asset protection planning, community property is a problem. Why is it a problem? Well, generally speaking, creditors can only go after those assets that our client owns, right? And creditors cannot go after those assets that our client does not own. So if you have a married couple, what are the assets? Let's say the husband is the one who's going to be sued. What are the assets that the husband owns? And this is a question that comes up often. Well, if I'm being sued, can they go after my spouse? No, they can't go after the spouse. Let's say the husband, was driving and he ran over I don't know, a troop of Girl Scouts, and a horrible example, but the one that sticks in your head, right? So let's say the husband is the one that's being sued. He was the one behind the wheel. It's a personal tort claim against him. It's nothing to do with his wife, right? She's not the one being sued. So the relevant question is not whether the plaintiff can go after the other spouse. The relevant question is, what are the assets that the husband owns that his plaintiff will be able to go after? And under California law, the husband's plaintiff will be able to go after his separate property, right? And community property. But what percentage of community property? And this is where we often get the wrong answer from a lot of people, right? The common answer is, well, his half share of community property. And that is not so. Community property is not owned 50-50. It is divided 50-50. It is owned 100-100. It's what's called the coextensive ownership interest. And each spouse is deemed to own all of the community property assets. And because the husband is deemed to own all of the community property assets, when he is being sued, all of the community property assets, and usually it doesn't matter how they're titled, will be exposed to his creditors, right? So when we're representing someone who is married, we are looking of possibly getting them out of the community property system. California makes that somewhat easier, right? Spouses can enter into a transmutation agreement, transmuting community property into separate property, or some form of a postnuptial agreement in which they will accomplish a transmutation of the assets. And once that is done, once they've transmuted, right, the husband now has his separate property and the wife has her separate property. So now the husband's creditor can go only after his separate property assets, and not all of the community property assets. So that's with the married couple, that's the very first structure we are looking to set up. Some form of a transmutation agreement has to be in writing. But a transmutation may not always be enough. So let's say the husband already ran over some pedestrians, engaging and planning after the fact, right? That late, right? When there's already a creditor with an existing claim against you. Whether a lawsuit has been brought or not is not really relevant. There's already someone with a claim against you. At that point in time, moving assets to the other spouse can be argued that it's avoidable conveyance. And just the fact that we're transmuting from community property to separate property does not somehow magically protect us from avoidable conveyance argument. So what else can we do to make that argument more difficult for the plaintiff? Well, some clients are willing to perhaps do a divorce, right? So why is a divorce helpful? Divorce itself is not what's helpful, right? It's the fact that we're splitting up the assets. Again, we're terminating community property in a divorce. The assets get split between the two spouses. But a divorce may be helpful because the divorce gives us cover for why the assets are being transferred, right? The assets are being transferred not because of the accident, but the assets are being transferred because the spouses decided to go through a divorce. And even a transfer of assets, even in the context of a divorce, is not something that's foolproof. There are cases where creditors have successfully challenged the transfers of assets in a divorce, and it has to be done just right. Like, it has to be an equal split of the assets, so it's a transfer for fair market value. And the case law does require the spouses to move apart. There was a Ninth Circuit case on this some years ago. Okay, so planning for a married couple, we are looking first and foremost of terminating community property and splitting up their community property assets into his and her separate property on an equal value basis. We're going to cherry pick who's going to get which asset based on how easy or difficult it is for a creditor to go after particular assets. But that's it for now. By the way, you guys do, if you do have my materials, I think you should. It's a really big white paper, 100+ pages. It goes through all of these topics just in a lot more detail. Moving on to the next structure, and let's go with the structure that I think, well, let's do a quick one first, and then I'm going to go to what I think is the heart and soul of asset protection planning. So another structure that we commonly see in asset protection are limited liability companies. So let's say that our client is being sued and they own this valuable cup of coffee that they want to protect, right? It's really delicious coffee that I'm enjoying right now. They want to keep it, right? So if, let's say, if I'm the one being sued and I own this cup of coffee, right? Theoretically, the plaintiff can take it from me. So what I do is I assign the ownership of this cup of coffee to a limited liability company, right? And once I've done that, I no longer own this cup of coffee. So can I drink it? Maybe not. I no longer own this cup of coffee. I now own a membership interest in a limited liability company. And why is that a better structure for me? Well, because a membership interest in a limited liability company is not subject to attachment by a creditor. Creditors' remedies under state law with respect to LLC interests, and by the way, the same is true for partnership interests, but we'll just talk about LLCs today. So membership interest in a limited liability company is not attachable by a creditor. They can't take it from you. There is no equivalent of like a stock turnover order that you would have in a corporation. So with an LLC, what a creditor can get is something equivalent really to a wage garnishment, right? So they can get a charging order, which is a lien on distribution. So any distributions that the LLC makes to me would now have to go to the creditor, right? So they would say, LLC, if Jacob is about to take a sip of coffee from this cup, which technically would be treated as a distribution, right, from the LLC to me, well, the LLC can't give me that sip of coffee. It now has to go to my creditors. Maybe a bit of a silly example, but that's how charging orders work, right? So any distributions of property from the LLC cannot go to the debtor member. If you have a charging order in place, the distribution of property has to go to the creditor. But if our client is in control of the LLC, what is he going to do? He is not going to make distributions, right? He's going to borrow the assets from the LLC. He is going to bring other members into the LLC and make distributions to them, right? Or he's just going to continue holding the assets in the LLC, frustrate the creditor long enough, and then settle, negotiate something with them, get them to walk away. So LLCs are great. And one of the reasons LLCs are great is because they're just so easy to use, no tax consequences, so inexpensive to set up. And they give us some decent, degree of protection. It's not a perfect level of protection. It's not something I would depend upon to somehow deter a very motivated creditor, but it's a lot better than nothing. So LLCs are frequently used in asset protection for that reason. So someone for some reason posted the homestead exemption in California. I guess that's helpful, but thank you. Let's move on to the structure that we really like for asset protection, and that's using a trust. So why a trust? Why is the asset protection community has always been enamored with using trust, and we continue to use trust to this day. So that goes to the goal of asset protection planning, which is what? Well, if a creditor can take from us those assets that we own, and they cannot take from us those assets that we do not own, the obvious asset protection play would be to take our client's asset, transfer it out of the client's name, and he no longer owns it. Well, does that mean that if we get sued, we can take the assets that we own and transfer them to the Salvation Army? Because once we give the assets to the Salvation Army, we no longer own those assets, right? And the plaintiff then cannot go after those assets. Well, first of all, if we do this last minute, even if the asset is transferred to the Salvation Army, the creditor may be able to claw it back because it should transfer for less than fair market value. But more importantly, our clients do not really intend to give away their assets, right? They're looking to place their assets inside of an asset protection structure as a means of either protecting them or giving themselves a better negotiating position, vis-a-vis creditors. So we're looking to get the asset out of the client's name, but do it in such a way so that they can retain control over the assets. They don't want to just give it away. Minimal to no tax consequences on the transfers, and the ability to get the assets back. And that's why we love trusts. So let me explain how that works in the context of a trust and what kind of a trust we would be using. The most common type of trust that we have in the United States is a trust that is irrevocable. Sort of the living trust, right? The family trust, we've all seen it. Most of you likely have it, your clients have it. And unfortunately, a trust that is revocable does absolutely nothing to protect our assets from creditor claims. So specifically under the probate code in California, and I think pretty much every state or whatever their equivalent code is, there is going to be a provision that provides that a creditor is allowed to go directly after assets that are titled in a trust that is revocable by the settlor debtor, right? So if I'm being sued, creditor is coming after my assets, and I transfer my assets into a trust that I have the ability to revoke, creditors go directly after the assets in the trust and get them from the trust. So they do not need to force me to revoke the trust. So every single asset protection trust must be irrevocable. And I want to spend a couple of minutes on this concept because it is often something that puts people off. It's a bit scary, at least at first. So, when I grew up in the law, so to speak, right? When I started practicing when I was in law school and for many years thereafter, an irrevocable trust was exactly just that. It was irrevocable. It was, cast in stone. It was unchangeable. The settlor of the trust could not get the assets back out of the trust. And if the settlor cannot get the assets back out of the trust, well, that's really difficult then to convince clients to use an irrevocable trust. Like how many of you would be willing to take your assets, right, and place them into an irrevocable trust and you have no ability to get the assets back? That's really difficult to do because, circumstances may change, your financial situation may change, your relationship with beneficiaries or the trustee may change, the laws can change. And it's very difficult to commit to an irrevocable trust. Well, fortunately, over the past 10 to 15 years, we as a legal community, as a trust drafting community, have developed the ability to draft and structure irrevocable trusts in such a way so that they're not really irrevocable, right? So what the law looks at least from a debtor-creditor standpoint, is that when the settlor transfers assets to a trust, they look at whether the settlor has retained the right to take the assets back. That is the power to revoke, right? The power to revoke is the power to take your assets back. It's not the power to terminate the trust, which is something entirely different. It's the power to take your assets back. We have some questions coming up. Give me a second. I'll come back to your questions on the homestead exemption. With the irrevocable trust, right? Old-fashioned can change it. New trust, first of all, we look at whether this settlor has the right to revoke the trust, get his assets back. And if you look at the California statutes, and these are uniform, so they're pretty much the same in every state, right? To test whether the trust is revocable or irrevocable, we test to see if the settlor of the trust has retained the power to take his assets back. So how these trusts used to be drafted for centuries, literally for centuries, right? Is there would be a provision in the trust agreement somewhere in the beginning which will say, this trust is irrevocable and it cannot be amended, it cannot be terminated, it cannot be revoked. And when you have this blanket prohibition on amending, terminating, revoking, it's blanket, right? No one can revoke or terminate the trust. But that goes well beyond what is required by state law to have a trust be considered irrevocable. We only need to take the power away from the settlor, which means that maybe it exists elsewhere with someone else, just cannot exist with the settlor. So first of all, we realized that we have always been drafting the irrevocable trust in a very inflexible way, right, in a very draconian way. So nowadays, we more often will draft irrevocable trust, which will say, well, the settlor cannot revoke the trust, the settlor cannot terminate the trust, the settlor cannot amend the trust. But then we preserve these powers in someone else, that someone else we usually call a trust protector, right? This is an appointment, an office in the trust relationship that's in existence to the, in addition to the trustee. And this usually winds up being the person you trust the most, right? So it can be a close friend, a family member, what have you, right? Because this is the person through whom the settlor of the trust retains control over the trust, right? So the settlor does not directly have these powers. The protector does. The power that is retained by the settlor is the power to remove and replace the protector. So in an indirect way, the settlor has control over the trust. So nowadays we have the ability to draft irrevocable trusts, set them up in such a way so that as far as third-party creditors are concerned, our client, the settlor of the trust, the one transferring assets to the trust, has no strings of control that they retain over the trust, right? But someone else out there exists with those strings of control. This is someone that we trust. This is someone who, not in the legal way, not obligated to carry out the wishes of the settlor, but we hope they will carry out the wishes of the settlor. And if they don't, then most likely they will be removed and someone else will be appointed who will be hopefully more agreeable. So I will say that, I will tell you from personal experience, we set up probably about 100 irrevocable trusts a year. And it's probably been a good 13, 14 years since we've last drafted an irrevocable trust that did not incorporate a trust protector. It's a beautiful concept. It really allows us to have an irrevocable trust and just retain so much control and flexibility. The irrevocable trust can be drafted or structured in a way to have no tax consequences. So no income tax consequences, no gift and estate tax consequences. So it's a beautiful structure. It really is a beautiful structure. So a couple of questions came up. One is saying that the homestead exemption in materials is a little bit outdated, which is surprising because I recall updating it, but maybe you guys somehow got a slightly older version of the materials. But you're right. So the current homestead exemption in California for at least the bigger counties is about $625,000. But that's kind of an aside from today's presentation. Except for a question from William, can the homestead exemption be applied to an irrevocable trust? And the answer is no. And that's actually a great question because very often when we are looking to protect, let's say, a client's personal residence, right, the very first thing we will ask the client with respect to their residence is, how much equity do you have in your residence, right? So we want to see how close are they to the $600,000 exemption. And if their equity is like really close to the homestead exemption amount, we are going to say, don't touch your residence. You're going to get a lot more protection from the homestead exemption. That's like ironclad, right? 100% you get the $600,000 adjusted for inflation. And if you transfer the residence to an irrevocable trust, like maybe the trust will work, right? Maybe it will work, but maybe not. And what happens if the trust doesn't work? Well, if it doesn't work, the creditor gets at the house that's in the trust, and they get whatever equity is in that residence. And the problem is that the homestead exemption is only available when the person who is claiming the exemption is using the property as their primary residence. And they own that residence, right? So if the residence has been transferred to an irrevocable trust, and the irrevocable trust is a third party, separate legal person, right? It has its own juridical existence. Once the property is in the hands of the irrevocable trust, the homestead exemption does not apply. So when we have real property, a home, I should say, not real property, we have someone's home and their equity is really close to the homestead exemption amount, we will tell them just rely on the homestead exemption amount. Do not do anything else with your property. Don't transfer title to a trust, LLC, or whoever else. If the equity that they have in their residence is very significant, like well in excess of the homestead exemption, let's say it's $1.5 million plus of equity, we would say, well, the homestead exemption is just not enough. And let's transfer the ownership of the property to an irrevocable trust and rely on the protection of the trust. And where it gets really difficult is when we're somewhat above the homestead exemption amount, right? Like let's say we have $900,000 of equity in the property. Well, the first 600,000 or so are covered by the homestead exemption amount. What about the next 300,000? And do we transfer the whole property to an irrevocable trust? Possibly get the trust to protect the entire 900,000 of equity, but lose the 100% certainty that the first 600,000 is protected. So that becomes a bit of a challenge to kind of work through that and make those decisions. Okay, but let's go back to, okay, would a revocable trust be able to use the homestead exemption? And the answer is yes, because a trust that's revocable is just ignored during the life of the settlor. Okay, so going back to the irrevocable trust. So every asset protection trust has to be an irrevocable trust. But if it's well drafted, if it utilizes the trust protector, right, it can function so much like a living trust, so much like a trust that's revocable. I mean, within like 99.9%, it can be just like a trust that is revocable. So for an irrevocable trust to be a good asset protection trust, what do we need to have? Okay, so it's irrevocable by the settlor, by the settlor, not globally irrevocable, just irrevocable by the settlor. The trust must incorporate the spendthrift provision, but I think nowadays pretty much every trust, right, has that kind of as a boilerplate provision. We want to give the trustee discretion when it comes to making distributions, and as much discretion as possible. We would like the trust to be what's called a fully discretionary trust, and a trust is considered fully discretionary if the trustee gets to decide when to make distributions, how much to distribute, and which beneficiaries to distribute to, including the ability to entirely exclude beneficiaries. So we want to have a discretionary trust. But even that is not enough to have a good asset protection trust, at least not in California. Because under California law, you cannot set up a trust like that for your own benefit and have it be an effective asset protection trust. So under California law, it has to be for the benefit of a third party. So kids are usually used by our clients, but it can be anyone. And again, if we're using a trust protector, we can give the trust protector the power to change the beneficiaries, terminate the trust, make our client the beneficiary, revoke the trust and the assets back to the settlor, or what have you. So it doesn't really matter who we classify, nominate as beneficiaries, at least during the life of our client. It's really just kind of a figurehead appointment. It just cannot be our client. So once we have a trust like that, it is a really good asset protection vehicle, and the assets that have been transferred to this trust are no longer our client's assets. Now they are titled in the name of the trustee of the trust, and not reachable by our client's creditors. And when I say not reachable, of course, there are exceptions to every rule, right? So under some circumstances, a creditor can challenge the transfer of the assets to the trust as avoidable conveyance, because that doesn't challenge the trust itself, right? It just challenges the transfer of the assets. And then it doesn't matter who the assets were transferred to, because the plaintiff may be able to claw them back. They can challenge the trust also on alter ego grounds, meaning that they're going to argue perhaps that, well, you did not deal with this trust in an arm's length fashion, like you didn't keep books and records for the trust. The trust made distributions to the settlor, so the settlor is de facto beneficiary of the trust. So, I mean, all these kind of arguments that you would make to pierce the corporate veil of a legal entity can likewise be made to pierce the corporate veil of a trust. And if they pierce the trust, then it is ignored and they can reach the assets of the trust. Question from Svetlana. Let's say client has a revocable trust and there is a claim against the husband. Is it too late to set up an irrevocable trust? Would it be possible to use a spendthrift provision and the trust protector to protect his revocable living trust assets? So in a revocable living trust, it does not matter what provisions you include: spendthrift, discretionary, third-party beneficiaries, protector. So long as our client has the right to revoke the trust, his creditors can reach the assets of the trust. So what we would be looking to do is maybe convert this living trust into an irrevocable trust, maybe take the assets out of the living trust entirely, put them into a completely different structure. And we're just kind of scratching the surface in this presentation on the different structures that are available. There are a lot of choices. So let's do this. Since we only have about 15 minutes remaining, I want to hit a couple of topics. We'll talk about offshore structures towards the very end. But let's spend a few minutes sort of as an illustration of how asset protection works in practice. And let's talk about how to protect someone's home, right? Get very, very specific. I'll give you an example of a transaction we're handling right now. I'm just going to disguise the facts slightly, not to identify to the world who our client is. So our client is a doctor. He was involved in a serious car accident. Fortunately, no one was killed or super seriously injured, but there were several people involved. And the lawsuit has been filed. I think they're asking for about $1.5 million. And although he's a doctor, this client, he's not like a dermatologist or a cosmetic surgeon, right? And he's not rolling in the dough. But he has some money, and his most important asset for him to protect, his most valuable asset, is his home. Home actually has about $1.5 million of equity. So what do we do to protect that home? So we are, almost $1 million over the homestead exemption amount. So we can't just rely on the homestead exemption alone, right? There's another $900,000 approximately of equity on top of it. He does not want to give it to the plaintiff. And more importantly, he has little kids who live in this home. So he doesn't want just the plaintiff to come in and foreclose on the home and kick them out, right? So what are his options with this home and with this $900,000 of equity that is not protected by the homestead? Well, from an asset protection, and especially because the accident already took place, he's already in litigation. The options are not going to be probably something that he likes, either because they're just not going to be very effective, or if they're effective, he's just not going to like it from a practical standpoint. So from a practical standpoint, the most effective thing that he can do to protect that $900,000 of extra equity is to sell the home. Sell the home, like really sell it. Not pretend sale, but a real sale. Take the $1.5 million of sale proceeds, maybe reduced by capital gain taxes, right? And then protect the sale proceeds. And the reason we want to do that is because real estate is an incredibly difficult asset to protect. No matter what we do with his home, his name will always be in the chain of title. How he transferred his home, what he transferred it to, what have you, will always be public information. And more importantly, a California judge will always have jurisdiction over that piece of real estate. So real estate, incredibly difficult to protect for these reasons. But if he's willing to sell the real estate and now he has cash is fungible, right? Cash is here today. It is in Europe tomorrow, maybe in some sort of offshore structure, which we'll discuss in a couple of minutes, right? And it's pretty much unreachable, right? This is the one structure we have where we can say to the client, your assets are now unreachable with like 99% certainty. So, and this is where it's important to look at the, what is going on with that client, because you can't just go to any client and say, sell your home. Almost no client is happy to hear that, right? They have their family living in that home and all of their stuff happens to be in that home. And just the thought of having to pack everything, uproot the kids, find a new place to live, right? Move everyone, change their address and everything. That's a daunting proposition. But what we always try to remind our clients is that, yes, it sucks to have to do that. It really does suck. But if we try different approaches and they do not work, what is end up going to happen, what it will wind up happening is that the plaintiff will proceed with a foreclosure sale and the county sheriff is going to sell the home. They're going to kick you out of that home and you still have to pack up and move. You will still have the income tax consequences of the sale, right? You still have to find a new place to live. And the only difference is who gets to keep the equity. If you sell voluntarily today, you get to keep the $1.5 million of equity. And if you're forced to sell tomorrow, you only get to keep the $600,000 of equity. Okay, so that's option one, sell the home, protect the cash. Option two, a similar proposition, we're pulling out the equity, but now we are pulling out the equity not by selling the home, but by borrowing against the home. So maybe they can refi their existing home. Maybe they can place another loan on the property, do a hard money loan, what have you. Maybe they have existing unsecured loans to some friendly parties, and they can refi those loans and use their home as collateral, right? And allow this friendly party to record a deed of trust. But we're looking for any which way we can to reduce that equity and drop the equity from $1.5 million to about 600,000, give or take. And then the third option, well, can we transfer title of the home out of the client's name? So maybe we transfer it to the other spouse and make it the separate property of the other spouse. Maybe we place it into an irrevocable trust for the benefit of the kids. Maybe we place it into something called the private retirement plan, which we will not get into, which is a California kind of specific structure. We usually will not transfer residences into a limited liability company because that's going to trigger the mortgage, the due on sale clause in the mortgage, whereas a transfer to a trust, if properly done, will not trigger the due on sale clause. We may have issues with property tax reassessment in California. And when we're transferring to a trust, much easier to get around property tax reassessment issues than transfers to LLCs or certainly to other people. So very, very, very difficult asset to protect the home, but for most of our clients, usually their most valuable and their most important asset to protect. But you have to know who the plaintiff is. One of my favorite client anecdotes some years ago, I represented a 97-year-old woman. She and a friend were driving to, I don't know, church, bingo, the liquor store. I don't know where 97-year-old people drive in the morning. And she ran into a parked car, minor accident, just some bruises and scrapes. And her friend quickly became a plaintiff and sued her for a couple of $100,000. And she had almost no car insurance, just whatever is like legal minimum. And she only had one asset, which was her home, but $300,000 of equity. This is when the homestead exemption was much lower. And she really wanted to keep that home. She's lived in that home for like 50 years, and she just wanted to live out the rest of her life in that home. That was so important to her. And we just ended up transferring the home to an irrevocable trust. And the plaintiff's lawyer didn't want to deal with it. They just walked away. She got to keep her home, happy ending, and I think the right ending, given that fact pattern. Okay, let's talk about offshore structures for 5 minutes, and then we can wrap it up. So what's an offshore structure? Well, there's a multitude of offshore structures. We can't just generalize it and say, oh, there's just this. In asset protection planning, though, one of the most commonly used offshore structures would be an offshore-based irrevocable trust. So just like the irrevocable trust we discussed earlier, that we would usually set up under California law, or in some cases maybe Nevada law or some other state, but this would be a very similar trust, but set up in a foreign jurisdiction. So why? A couple of reasons. First of all, there are jurisdictions that have, let's say, modernized their trust laws to make themselves much more debtor-friendly, to make it so much more difficult for creditors to pursue the assets inside of these trusts. So we would go to one of these jurisdictions. We would hire a trustee in one of those jurisdictions, and that in and of itself is advantageous because now the party administering the trust is beyond the jurisdiction of a U.S. court, which is much better than a domestic trust that has a U.S.-based trustee. We would make sure that the protector of the trust is also outside of the United States. And then we look at where would the assets of the trust be located. We would make sure that the assets of the trust are also outside of the United States. So really place both the ownership structure and the asset itself beyond the jurisdiction of a U.S. judge. And you can only do that with liquid assets, right? You can't place real estate in a foreign trust in a sense that you're not really removing it from the U.S. You're not really removing the real estate from the jurisdiction of a U.S. judge. But liquid assets you can, right? They're in a bank account in the U.S. tomorrow, and they're in a bank account in Europe tomorrow, owned through some sort of an offshore trust. But there are a lot of different structures. There are offshore private foundations. There are all sort of sandwich structures, hybrid structures. There are double trust structures. There are structures where we're just setting up that investment account without any sort of trusts or LLCs, but the way we structure the investment account for the client in Europe has asset protection built in and of itself. We're going to countries that will not enforce a U.S. judgment or will make it incredibly difficult to enforce a U.S. judgment. All those are good asset protection tools. Question from Linda. Is it true that a transfer of asset when a suit is pending is a fraudulent transfer and reversible? So this is a very common misconception. Nothing is a fraudulent transfer in and of itself, right? It could be, right? But so the plaintiff, the creditor would have to challenge the transfer as a fraudulent transfer, and they then may be successful in that challenge, or they may fail. And then if they are successful, the judge would rule that, yes, this was a fraudulent transfer, and your remedy is to go and recover the transferred asset. So a fraudulent transfer lawsuit, or what nowadays is called avoidable conveyance lawsuit, it's a lawsuit against the transferee, because that's who you would recover the asset from. But just because the asset was transferred at the last minute doesn't mean that it's automatically reversible. It has to be challenged as such. And as I said, our statistics are that we see those challenges in about 1% of cases. And yet sometimes they're successful and sometimes they're not successful. And sometimes our clients are just sort of playing those odds, and the odds just happen to be overwhelmingly in the debtor's favor, just because it's so rare to see creditors go through these extreme remedies. Guys, if you have any more questions, I'm very happy to stay and answer them. But I will just, for the rest of you, say thank you so much for listening. If you have any questions, again, email me. My email is jstein@alliantlaw.com. It's in your materials, and I'll just put it into the chat box right now. Thank you so much. I appreciate your attention. Question in addition to your slides, which resources do you recommend to learn more on this topic? So you have the slides, you do have my white paper, which is very lengthy. There are some couple treatises on asset protection. I think Duncan Ostroff has a treatise. I forget who the publisher is, one of the big legal publishing houses. There's an older one by Peter Spiro. There are articles here and there, but other than a couple treatises, there's really not a lot on the subject outside of articles and some books. And I do have a book, I should say. I did publish a book called California Lawyer's Guide to Asset Protection Planning, specific to California. And I think it's on Amazon. Thank you, guys.